Good morning to all of you. Welcome to ethics class. Friends, we are today discussing the part C of question paper 2022, question number 15. Without wasting much of time, let us quickly go to the problem. Friends, I do not have the problems with me, but anyway, I have noted down the gist of the problem and you can study the problem. X, an advocate, question number 15. X, an advocate, used defamatory words on the client. He used the same in order to get the real facts, but the judge raised an objection. 100% correct. So, what does it mean? So, please remember, everybody has got a name and fame. You cannot defame anybody. If you defame anybody, as per the discussion, it will amount to an offence under section 499 of the Indian Penal Code. Or you can file a case of tort. Or you can file a civil suit under section 26 of the Code of Civil Procedure and claim damages from him. Number one, he cannot use the defamatory words. Right? And secondly, since we are discussing the Professional Ethics Advocates Act, rule number 35, yes, it says the advocate should do his best to carry out all legitimate promises to the opposite party. So you have to give respect to him. You have to treat him just like your opponent, that's all. He is not your enemy. You have to treat him properly. You have to put the proper questions. But you should not put the defamatory questions against him. మీకు తెలిసే ఉంటుంది, మీ అమ్మ ఉందా లేకపోతే మీ నాన్న ఉన్నాడా లేకపోతే మీ అమ్మ మగుడు ఉన్నాడా, హౌ ఇట్ విల్ బి? యూ షుడ్ నాట్ యూజ్ సచ్ వర్డ్స్ బిఫోర్ ద కోర్ట్, ఇస్ ఇట్ నాట్? ఇట్ విల్ బి defamatory. And as per section 148 of the Indian Evidence Act, the judge is the final arbiter. Definitely he will raise objection and he will say, this question you can't put, that's all. You cannot do anything. Just like Speaker of the Assembly, if he says this will not go into the record, this will be expunged. Yes, it has to be expunged, that's all. So please remember, according to Rule 35, you have to give courtesy to the opposite party. No doubt, here the intention is to extract the real facts. No doubt, the purpose of the cross-examination is only that. But there is a way. There is a way to examine him. You have to be polite towards him. You have to be courteous towards him. You can put the question you like, but not in a defamatory way. Right? So this is what I want to tell regarding the particular question. So section 148 Evidence Act says, please remember, court can decide which question can be asked, for which witness can be compelled to answer, and for which witness need not answer. So please remember, and in this correction you all know, negative fact need not be proved. Now we'll go to the case laws, important case laws. So first case law is Noratan Mal, N-O-R-A, Noratan Mal Chaurasia versus M.R. Murali, the advocate, 1999. Right. So please remember, the advocate appearing on behalf of actually appearing as a litigant, that is M.R. Murali, he was himself appearing in a rent control case. So he did not evict the office, he did not vacate the office. Therefore, this Chaurasia person, he filed a case of rent control against him. The matters were going on. Ultimately, on one day, he assaulted and kicked the complainant and asked him to refrain from proceeding with the case. This happened on two occasions. Number one occasion, he threatened him. On the second occasion, he kicked him literally while coming out from the court. Actually, this did not occur inside the court. Just outside the premises of the court only it happened. He assaulted the other person. This is what you should not do. You should give courtesy. You should be courteous to the other party also. It was taken as a professional misconduct under section 35 of the Advocates Act. Supreme Court said, a lawyer is obliged to observe the norms of behavior. So, the norms of behavior which are expected of him as an officer of the court. His behavior makes him unfit. Disciplinary action can be taken against him. Finish. Second case, Hikmat Ali Khan versus Ishwar Prasad Arya, 1997. So here also, this Ishwar Prasad Arya was convicted for 3 years under section 307 of the IPC for attacking his adversary, that is Radhe Shyam, in the open court with a knife. During lunchtime it happened, and he used when he was convicted for 3 years or 7 years, then when he is jailed, he has made a forged document stating that the governor of Uttar Pradesh pardoned him or commuted his sentence under Article 161 of the Constitution of India. So ultimately, Hikmat Ali Khan filed a case against him. So when the facts came to light, he was debarred from practice. So these two cases are more important. So you should not use defamatory words against the opposite party. You should not assault the opposite party. You should not you should not attempt to kill the opposite party. So this is what Rule 35 says. Rule 35 is a violation if you do not do these things, right? So conclusion. Here to conclude, basing on the above case laws, it is a clear violation of Rule 35 and the court is justified in objecting to the questions, defamatory words put by the advocates. Okay, if you write this much, it will be sufficient. Thank you.